reading of a sale of shares agreement. I will go through line by line of the sale of shares agreement and what provisions and clauses are expected in a sale of shares agreement in accordance to the Legal Practice Council board exam. 1. The parties to this agreement are the seller, including FICA details, the purchaser, including FICA details, ABC Investments, Pty Limited, the company, duly represented by specify a person, a legal person, and FICA details. 2. Definitions. For purposes of this agreement, unless otherwise stated, company means ABC Investments Pty Limited, registered number, principal, place of business. Claims means any claim which the seller has on the shareholder loan account as at the date of signature. Documents of title means 1. The share certificate in respect of the shares. 2. A share transfer form in respect of the shares signed by the seller in blank. 3. A written cessation ceding the claims to the purchaser or its nominee. 4. Any written resolution of the members of the company of the board of directors, which is necessary to successfully implement the terms of this agreement. 5. The written resignation of those of the directors, public officers, secretaries, other officers of the company whose resignations have been required by the purchaser. 6. The resignation of the company's auditor if so required by the purchaser. Shares means 100 shares in the capital of the company, constitution, specified percentage of the entire issued share capital of the company, registered in the name of the seller. Signature means the signature of this agreement by both the seller and the purchaser. 3. The subject matter. The seller sells to the purchaser the shares and the claims. 4. Purchase price. 4.1. The purchase price in specified rands. 4.2. The purchaser must pay the price and any interest thereon in cash without deduction or set-off to the seller at the seller's chosen service address in terms hereof. 4.3. The purchaser must pay 4.3.1 specified rands within 7 days of signature. 4.3.2. The balance of specified rands together with any interest thereon in monthly installments on the first day of each successive month until the full amount owing has been paid in full. 4.4. With effect from date of transfer of the shares and claims, the purchaser must pay interest on the balance of the price outstanding from time to time. 4.4.1. The rate of interest will be the prime overdraft rate recorded by the South African Reserve Bank from time to time and will compound monthly in advance. 5. Security for payment. 5.1. The buyer must within 7 days of signature deliver to the seller a suretyship undertaking by credit provider in favor of the seller guaranteeing payment of the balance of the price and interest in terms of this agreement. 5.2. Until the final portion of the purchase price has been paid to the seller, the buyer understands and undertakes to cede all rights in the company to the seller as security. 5.3. The buyer warrants that he will not sell the shares to any other creditor before they are paid in full to the seller, inasmuch as the buyer breaches this clause, and without detracting from the rights which the seller will have in this event. The buyer cedes any reversionary rights which he might have in case such shares as security for the due payment of the buyer's obligation in terms of the agreement towards the seller. 6. Delivery of documents of title. The seller must within 7 days of signature deliver the documents to the title to the buyers at the latter's chosen service address in terms of this agreement. The seller shall on effective date, otherwise known as signature date, deliver to the purchaser the following documents: the share certificate in respect of the subject shares occupied by share transfer forms, currently dated and executed in blank by the registered holder thereof, so as to enable such shares to be registered in the name of the purchaser or its nominee. A written succession ceding the claims to the purchaser or its nominee. A resolution duly passed by the Board of Directors of the company approving the transactions set out in the agreement. 7. Ownership and risk. Ownership in the shares will pass to the buyer on delivery of the documents of title. The seller cedes the claims to the buyer with effect from the date of which the documents of title are delivered to the buyer. 7.2. The risk attaching to and benefit of shares and claims will pass to the buyer on the date of which ownership and shares and claims pass to the buyer in terms of 7.1. 8. Warranties. The seller sells the shares and claims footnotes, it being recorded that the seller gives no warranties or guarantees of any nature. Or, the seller warrants and represents that he is the beneficial owner of the shares which are fully paid. He is able to deliver to the purchaser good title in and to the shares. Neither the members of the company nor its directors have passed or agreed to pass any resolution for the increase of the capital of the company or for the issue of any other shares in the company, and that no such resolution be passed prior to the transfer of the shares. Any rights of preemption in respect of the shares or any portion thereof, whether granted by the Articles of Association in the company or otherwise, will be waived. The books and records of the company accurately reflect, in accordance accepted accounting principles, its financial affairs and all transactions to which it has been party. The company is not engaged in any tax appeals, arbitration and criminal proceedings, labor disputes, competition or consumer commission inquiries, or any other tribunal inquiries or litigation other than proceedings for the collection of debts from debtors in ordinary course of business. The seller warrants or represents that he is not aware of any matter in respect of the shares or the company which have any bearing on the acquisition of equity by the purchaser. 9. Announcements. Neither party will make any public announcement relating to the transaction in this agreement or its terms, unless the manner of making such an announcement, the time when it's made, and the terms of the announcements have been agreed with other parties in advance. 10. Resignation. The seller resigns as a director of the company with effect from the date of signature of this agreement. 11. Breach. In the event of the buyer defaulting in any respect of any amount due by him to the seller in terms of the agreement, the full amount of the purchase price together with the interest thereon will become immediately without notice due and payable by the buyer, and interest on such amount will occur at the rate and calculated in a manner provided for in this agreement. 11.2. Without prejudice to and in addition to any other rights in which either of the parties may have, whether under this agreement or at law, in the event of either party committing any breach of this agreement and failing to remedy breach within 10 days of being called upon in writing to do so by the other party may cancel this agreement. Signed. In conclusion, a sale of shares agreement consists then of the following: common terms, which speak to breach, governing law, costs, recovery of costs, resignation of the directors, meeting of on the closing date to pay purchase price, warranties by the seller, title, waiver or preemptive rights, method of payment of how the purchase price will be paid, acceleration clause of payment on default, the delivery and date of transfer, exclusion of reliance by either party on prior statements and representation, and subsequent informal variations, termination of the contract. And lastly, security of payment and how the mode of payment will take form before the share certificate is transferred. The sale of shares agreement is part of drafting of contracts, and some of these clauses are common. However, most of them are specific to a sale of shares agreement. I wish you all the best in drafting a sale of shares agreement in the board exam.